Welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge in an area of law that we practice in. And so we welcome you. I'm Senior Staff Attorney Susan Ingalls, and I'm here with our producer, Kenneth Elliott, who has been helping me get started here today. And we'll be talking today about the Married Women's Property Act and some other sort of related laws a little bit as we celebrate Women's History Month. Before we get started, I do want to mention that we have a couple of other future episodes that will be a little bit related to this. While it's Women's History Month, we have a special presentation on March 29th. And then next week on March 22nd, we'll be talking about the some changes and update on the child care tax credit, since our tax reporting is coming up in April. So hopefully you'll tune in for those as well. We do want you to remember that today's presentation is not legal advice. It's just general information for you, the public. And so we hope it will be helpful to you. But if you do need an attorney for this type of issue or any other issue that we do handle, be sure to apply for our services. And you can do that online or by telephone, or in an emergency, you can do it at our local offices. All that information will be provided at the end of our presentation today. So let's go ahead and get started. So today we're going to be talking about women's property rights in South Carolina. Specifically, we're just going to review something that you may not have heard of, which is the Married Women's Property Act, which has been around for a long time, but as legislation comes and goes and case law comes and goes, things can change. And so we'll be also looking at some other laws that affect women's property rights. So a little bit about the history of Married Women's Property Acts. These started really in the late 19th century, after the Civil War was over. And it started to happen a lot during Reconstruction and later as time progressed. And so the idea behind some of those acts was that, you know, as one of my constitutional law professors in law school used to say, the husband and wife are one, and that one is the husband. And that's how it was back in those days. Women did not have a lot of rights to property, although there was something called a Dower right, which we'll touch on. But anyway, there has been a lot of change over the years as married women and unmarried women as well have started to not only have property rights, but assert those rights. And there can be many, many effects, whether it be on the family, on economics, on labor, on education. So a lot has happened since the Married Women's Property Act was issued in South Carolina. So let's talk about South Carolina Married Women's Property Act, which is found in, starting in our South Carolina Code of Laws 20-5-10. So all of this happened because married women really did not have much in the way of property rights. And so as we go through the several provisions, you'll see that what the power or the right that is given to the woman is one that she didn't have before. So for example, just starting out here, we see that the married woman is given the right to actually purchase property in her own name. How about that for an idea? We do that all the time nowadays, but it used to be, you know, you couldn't do that. As well, women are able to contract on their own in the same manner as if they were unmarried. So somehow, if you were unmarried, you might have had the right to contract, but if you were married, that right really emanated from your husband and the marriage. Not necessarily true anymore. And also, those contracts that you now enter into as a woman can be enforced against you in your own name, apart from your husband. So back in the day, a contract could be enforced not only against the married woman, but also against the husband. It was a combination, basically. Nothing was the married woman's rights on her own. So now that we as women are able to own property in our own name and have been able to do so for a long time, the next thing that flows from that is the right to do something with that property. So the next section, which is 20-5-20, gives a married woman the right to basically convey that property, deed that property to someone else, give it to someone in their will, gift that property to someone, because they do have the full rights of ownership. And that's, as it says here in the section, the same as if she were unmarried, and also dying intestate. The property goes to her descendants. Intestate, as you may or may not know, means you die without a will. So you haven't devised the property or bequeathed it in a will to anyone, whether it be your family or other individuals. And so if you, as a woman, die intestate, then your property is going to go under what we call the intestacy statute, which provides who your property goes to at your death, property that you own, who it goes to at your death, if you don't have a will. And so that tends to be a spouse and children. And then if you have no spouse or children, then to other blood relatives. So, the property doesn't just automatically go to your husband. And then deeds, mortgages, and any other instruments that are executed regarding the property, which can be many, but the mortgage is the one we most often think of. Then that's going to have the same legal effect with a married woman signing it as it would as if she were unmarried. So let's go on to the next section, which is 20-5-30. And this is an important one. The wife's property is not subject to the husband's debts. Okay, so here we see the real and personal property of a married woman is not subject to the debts of her husband. So we still have laws that allow property that you have to be sold to pay a judgment debt that you have. Okay, we don't have debtor's prison anymore or anything like that. But if you have a judgment against you for a debt, then that judgment does give the judgment holder the right to ask a court to sell property that you own in order to satisfy that judgment. We do have certain exemptions, and we talk about that more in another episode of Level Up Law, which we'll link here. But in any event, that is always something that can be done with your property. Now, just because you are married doesn't mean that your spouse's property is subject to that. And that was particularly true to make sure that while the married woman's right is being honored here in this section, that we also connect that with that husband's or spouse's debt, and make sure that a husband's debt is not going to encumber his wife's property. And that's to protect the rights of the wife, obviously. I just wanted to note here that there are laws that can affect this particular issue, and that is if a husband and wife are filing a joint bankruptcy. There's a lot of other laws that would apply and have to be considered in that situation. And then also, if the married couple is divorcing and there's an equitable division, then sometimes you're dividing debts and assets. They're not necessarily causing a levy or sale of property by way of the debts. And you always have to keep in mind that a family court judge in a divorce cannot order one party to be removed from a debt. In other words, when you as a married person or an unmarried person incur a debt, the family court does not have the right to make an order that affects that debtor-creditor relationship. They can say, well, the husband or wife has to pay a particular debt, but they can't take the other spouse's name off of that debt in any way. And we see that a lot with mortgages and credit card debt, where a spouse who's not going to be responsible for that debt wants to be removed from the debt. But that is for the creditor to do, not for the family court to do. Okay. The next one, and it looks kind of like I'm going backwards here, section 20-5-40. Now, this is about the married woman's income, and there has been, case law and development of the concept of whether or not a married woman's income is property. And income is not considered to be property, or earnings not considered to be property. And so this says all the earnings and income of a married woman shall be her own separate estate and shall be governed by the same provisions of law as apply to her other separate estate. And there, of course, they're referring to actual assets or property, real and personal property. So a married woman's earnings and income cannot somehow become the estate of her husband. That is something that only really is dealt with in a divorce situation. Okay, 20-5-50, and this talks about what has to be in a deed or a contract or any sort of settlement. And this is one of the longer provisions of the Act. And one focus here is that you really do have to describe the property very comprehensively that is being conveyed in some way, or if there is a marriage contract, and that has to be very particularly described. And so there has to be a schedule of all the real and personal property that's being affected by a contract or a deed or a settlement. And in particular, if there's not such an attachment to that contract or deed or settlement, then it's going to be a fraudulent, null and void agreement as to any creditors or bona fide purchasers or mortgagees. And mortgagee is the mortgage company, basically. So that can get a little bit complicated, but it's important to specify that this particular property that is going to be covered by the contract deed or settlement. Okay, now 20-5-60, the husband is not liable for the debts of his wife that are contracted prior to or after their marriage, except for her necessary support and that of their minor children that are residing with her. Okay, so the husband's not liable for his wife's debts, only those debts that were during the marriage. An exception to that might be if the husband takes on the debt in some official way, in other words, becomes a debtor on the particular account or something like that. But that would be, I think, a rare circumstance. The one thing I want to mention here, and you can see they're talking about the exception for necessary support of the wife and the minor children. So there's something we have called the doctrine of necessaries, and we also have a level up law episode on that, which we'll link to this video. But the doctrine of necessaries applies both to wives and to husbands, and it requires that your property is subject to a debt of your spouse if it's a necessary debt, and we typically think of that as something like a hospital or other medical debt. So be careful about that. And then 20-5-70, neither a husband nor his property is going to be liable for recovery against the wife in a suit brought against her. Judgment in any such suit may be enforced by execution against her sole and separate estate in the same manner as if she were the sole owner. So the husband is not going to be liable for the debts of his wife. At least if he has property of his own, then it can't be sold for the wife's debt. And again, that is an exception there would be that doctrine of necessaries that we talked about before. And we certainly had cases like that here at South Carolina Legal Services where, for example, a house is in the name of the wife only, or the house is in the name of the husband only. And depending on the value of the house, sometimes it can't be protected through our state exemptions from a judgment that the judgment holder seeks to have that house sold for. And they will do that under the doctrine of necessaries. So, for example, if the wife has a very large hospital debt and no property, but her husband has property that has no mortgage or anything on it, and that has a very high value, it would have to be something over around $62,000. And if that's the case, and it's only in his name, then that property can be subject to being sold to pay that hospital debt of the wife. But keep in mind, there has to be a judgment against the wife for that, in the example, for that hospital debt. So there has to be an opportunity for both parties, the husband and the wife, to challenge that debt in court. And then 20-5-80, and this is just validating, certain deeds that have already happened. So 1868 is actually when the Married Women's Property Act came into being. And so there were a lot of property rights and conveyances, that had already happened. So this has the effect of basically saying that those will be good and effective under the law anything before the passage of this act, but then after the passage of the act will be what prevails in making that determination. Okay, so a couple of other just property related laws that do have to do with women's rights. And of course, these laws have to do with both men and women. But we're talking today about married women and other Women's Property Act related laws. So let's talk about dower rights. Now, back in the day, it was not a statute like the one we've just been looking at, but there was a common law right to dower. And I can even remember, because this changed with the Boan versus Wilson case in 1984, a couple of years after I graduated from law school. And so what women had to do when their husband was conveying property that he had an interest in, the woman had to separately sign and grant any dower right that she had, which is typically was a third interest in the property, I believe. And so we would have to, because I did real estate law when I was in private practice. But anyway, when the husband would be signing a deed, we would have to take the wife into a separate room and explain to her that she had the dower right in the property and that the husband could not convey the property without her signing over her dower right, because otherwise he was not conveying the full interest in the property. And so the woman would have to sign away her dower rights before a notary at that point, and then they could return to everyone else with the closing, for example, if they were selling their house or something like that. And so that was abolished in 1984, and so you don't have to do that anymore. But of course, we do have intestacy rights when it comes to probating a will or an estate. So there is some protection for husbands and wives in that regard. But the dower right was abolished by this case in South Carolina. And one of the things that the court noted in that opinion is that all those type of laws had long since been gone, abolished, or legislation passed that made them no longer effective. So it was time to include the dower right in that as well. So if you ever hear about women signing away their dower rights, that's what they're talking about. Now, dowry, which is spelled D-O-W-R-Y, is a totally different thing, where a future husband would pay the father of the bride a dowry. But anyway, that's something totally different from dower rights. Okay. Now, we can also talk just a little bit when it comes to married women's property rights, equitable division. And so property that is owned by spouses during marriage, it can be or is going to be divided in a divorce if the couple is getting a divorce. And so that's a whole different set of rules. And we'll be talking about equitable division and some other family court issues more in this series for Level Up Law in June of this year. So stay tuned for that. We'll be talking about temporary hearings, equitable division. You might note that we've already had an episode that talks about the financial declaration that's required to be filed in a divorce. So that's where each party is listing their income and their expenses, but also their assets and their debts. And that's where the equitable division rules come into play. And so this is something that a family court judge is going to decide unless you have come to an agreement or you have some other agreement prior to the marriage or even a cohabitation that you have agreed to and that you've done it in the proper way such that it is an enforceable contract. And that's something that you really have to do through a lawyer. But I just wanted to note that there's 16 factors that a family court judge uses to determine equitable division of marital assets. And you know, sometimes you think, well, I owned that before the marriage. Well, that can become a marital asset, and there's several ways that that can happen during a marriage. And we'll talk about that more when we talk about equitable division in a later episode, but just suffice it to say that you need to be careful if you have property that you acquired before a marriage and you want that to stay your own property as a spouse, really whether it be husband or wife. You can keep that non-marital asset as non-marital, but you can't, you got to be careful that it doesn't get put together with marital property. For example, by conveying an interest to your spouse, or paying the mortgage on the house, or you know, adding a renovation, or you know, adding to the home and incurring debt for that. So there's many ways that you can acquire an interest, or that an interest can become marital when it was previously non-marital. And then I wanted to just briefly mention cohabitation agreements. So I think in today's world, there's a lot more cohabitation without marriage, and sometimes the couple will have a cohabitation agreement, which can be a really good idea, particularly if you're bringing a lot of property or other assets to the cohabitation. And so, yeah, if you're married, there's a whole set of laws that covers that, which we just mentioned. But if you're not married and you split up, nothing protects you really. If you have a cohabitation agreement, hopefully drawn up by a lawyer, then that can potentially be enforceable, so that you can refer to that as to how to distribute the shared assets. If you buy something together, that you know, hopefully that will be covered in your cohabitation agreement. There's a lot of things like that that you should think about before you start living with a person and acquiring property together. So a cohabitation agreement does just that. It's going to establish who owns what. You know, I brought these things into the cohabitation. You brought these things into the cohabitation, and you know, anything that we pay for separately will be our own personal property, and you know, things like that. You might address what the living arrangement is, so that if one of you is the owner of a home and the other partner moves into the home, that's a living arrangement that you need to kind of lay out what that means, because it's one thing to have the divorce laws that assist with who can stay in a home, but if you're just cohabiting and only one person owns the home, that can get a little more tricky. And there's many other, you know, legal issues, whether it be who's paying what bills, like utilities, mortgage, anything like that. All of those kind of things can be put into a cohabitation agreement. And as we note here, the one thing to think about is if you have children and you're not married, you're just cohabitating, you can't cover that in a cohabitation agreement. That has to be, anything regarding children has to be determined by the family court in South Carolina, because obviously the best interest of the children is what's the most important, and that's for the court to decide. If you as a couple have made that decision and you abide by it, that's one thing. But if there's any disagreement, a cohabitation agreement having to do with children is not really enforceable as to children and the rights that surround them. So that's all I have for today on this subject of the Married Women's Property Rights Act and some of those related matters. But I do urge you to stay tuned for more on some of those subjects. As I said, on March 29th, the final Tuesday in Women's History Month, we'll be partnering with the South Carolina Department on Aging to bring you some historical nuggets and some great information about common law marriage, as well as some of the things you need to look out for to make sure to protect your legal rights as a woman. So definitely stay tuned for those. And you can see on your screen how to get in touch with South Carolina Legal Services by telephone or online. So that way you can do it any time of day or night, apply for our services. Our intake specialists are always standing by on the telephone from Monday through Thursday, 9 to 6. And if you apply online, you may get a call back from one of them just to, you know, clarify something that you may have put in your application or something like that. But otherwise, it should go right on through to a local office where you live. And then also, as always, I want to encourage everyone to access all of the resources that we have that can be helpful to you on this and other subjects that we cover. As lawyers here at South Carolina Legal Services, our Law Help page has quite a lot of resources. sclegal.org is our main law firm website. And you can always find out about what's happening in your area on the calendar on that website. And then always you should look at our YouTube channel, because that's where we upload these Level Up Law episode recordings and a lot of other great informational videos in all the areas of law that we practice in. So I definitely encourage you to go there and subscribe to our YouTube channel and all of our other social media to keep informed and up to date about what's going on and what new and informative resources you might find if you're following us. You know, while you're there at the YouTube channel, be sure to like this video if it was helpful to you, and definitely share it with other people who might find it interesting or helpful to them if there's someone you know that's wondering about that. It's good to know that our state enacted with all the other states at the time the Married Women's Property Rights Act, and you know, a lot has happened since then. Any number of things, including the Equal Credit Opportunity Act, which we'll have an upcoming episode on as well. So just stay tuned for any other subjects that you might have an interest in, and we appreciate you as an audience tuning in every Tuesday and watching these videos on YouTube and sharing them with others. So thanks so much for doing that. And do tune in next week for our episode on just really an update, I guess you would call it, on the child care tax credit with our LITC, Low Income Taxpayer Clinic attorney, Mr. Fred File. So until then, thanks for tuning in, everybody. We appreciate you joining us. That concludes today's webinar.